Yes. Now, I just wanted to make mention of something. In July 11th, yes. My record was expunged, and I think we'll start with that. Yes. The expungement. Oh, now I noticed that when I went to send some emails today, that somebody had put all the emails I deleted, yes, back on my Outlook account. Yes. Could you give me every IP address that has accessed any of my email accounts for the last, 20 years? Yes, just call Microsoft. Now, I'm wanting to know how deleted emails ended up back in my inbox. Yes. And then I wanted to know why it is that you're not enforcing the laws of the United States. Seemed like somebody was obstructing my right to communicate with those in office about the obligation to enforce the actual laws of the United States. It was you were more concerned about the actual debt necessary to get elected to office than the office that you thought you were going to take today. Now, what happens when I find out that campaign contributors will only contribute to your campaign if you actually win the election? What happens to the losers? They have to mortgage their houses. I think there should be laws against only making contributions to those that are winners. It's kind of hedging your bets, is it? You would think that any person that supports any individual that's going to get elected for office, isn't that right, Sheriff? That the whole concept of making contributions after the election, yes, should not have any conditions of whether or not you actually are elected to office. Now, for every American citizen that said, "Well, since you did win, I'm going to make a contribution to to your election," yes, I just want to know all the assets of every person elected to office before the ballots were counted. Every loan of every candidate for office, and then I want to know all the campaign contributions after getting elected to office. Now, this concept of, well, I'm going to borrow some money to get myself elected, and then I'm going to have some campaign contributors that are going to pay the loans off for me. Now, there was a matter that came before the Honorable Michael J. Bardolo on July 11th of 2012, and there was evidence being presented to the satisfaction of the court. What exactly was that evidence? Pooh. Well, let's think about evidence. Evidence of bribery, evidence of corruption, evidence of kidnapping, evidence. You say I have no evidence of your crimes. Pooch. After 2 million emails and having gone through this protection order numerous times, yes, exactly what evidence is there? Ooh. Let's see. Respondent is restrained from coming near and having any contact whatsoever in person or through others. That would be the third party contact. Yes. By phone, mail, or any means directly or indirectly. Ooch, ooch. Except for mailing, or service of process of court documents by a third party or contact by respondent's lawyers with the petitioner and the minor's name in the table above. Yes. Now, the evidence is that I could have a service or process of court documents. Yes. By a third party. Oh, does anybody know where Heidi's living right now? Oops, look at that. Or contact by the respondent's lawyer with the petitioners and the minors named in the table above. Ooch. Now, I never contacted whatsoever through the phone. Yes, as in this telephone that has never rang because no one enforces the laws of the United States. I haven't emailed or sent any mail to the respondent or the minors named directly or indirectly. Ooch. But except for mailing or service of process of court documents, mailing or service of process. Now let's see. Mailing or service of process of court documents. by a third party or contact by a respondent's lawyer with the petitioner and the minors named. Now, you remember that attorney that you refused to acknowledge that I have the right to have? Yes. I've had multiple public defenders that none of them have actually contacted the petitioner or the minors named. Ooh. You would have thought that when I told Bruce Hanafy, I want you to motion the court and I want you to remove the protection order, and I did that in February of 2016 because I was on personal recognizance, Judge Porter, and the law required me to contact him within 48 hours. Now, you would have thought, yes, that the judge would have removed the protection order because I don't know where the petitioner is. Yes. See, she didn't sign it. She didn't acknowledge it. There can't be a possible address for her unless somebody decided to fill out the paperwork other than the petitioner. Is that the actual address or contract? Well, there's a lawsuit here if you see it. Let's say that the sheriff's department took it upon themselves to fill out all the information necessary for a protection order without actually verifying the address of the petitioner. Does anybody know where she's at? Now, since the petitioner didn't acknowledge it, she didn't acknowledge any of her own personal information. We spent a few weeks on exactly how these forms are filled out. In fact, I have, the extreme protection order, the special protection order. Now let's just look at it just for a second, okay? You refuse to acknowledge any forgery or fraud. Pooh. The petitioner did not acknowledge the court order. Yes. And I have no idea if she was there or if any of the information that was provided to law enforcement was actually factual. Have you intentionally been obstructing my right to contact the petitioner through an attorney that you deprived me of?